Generally, a joint tenancy is land ownership by one or more concurrent owners with the right of survivorship. But what if a joint tenant conveys his or her interest in the property to a third party who doesn't record that interest until after the joint tenant dies? Does this conveyance terminate the joint tenancy and extinguish the right of survivorship? The Utah Court of Appeals considered this question in Crowther v. Mower. Husband and wife Dean and Nellie Crowther owned land in Utah as joint tenants. In December of 1988, Nellie executed a quitclaim deed conveying her one-half interest in the land to her son, Bryan Mower, who lived in California. Nellie's attorney then sent Mower the deed, along with a copy of the codicil to Nellie's will, by certified mail. In a letter, the attorney stated that Nellie intended to transfer ownership of the property to Mower. The attorney also stated that Nellie intended for Mower to receive a one-half interest in the property and wished to leave the other one-half interest to her stepchildren. Further, the attorney instructed Mower that if Nellie were to die before Dean, Mower should record the deed immediately. But if Dean were to die first, Mower should contact Nellie to discuss matters. In August of 1991, Nellie died first. 6 days later, Mower recorded the deed. Subsequently, Dean sued Mower in state district court to quiet title. Specifically, Dean argued that the deed didn't terminate the joint tenancy because Mower didn't record the deed before Nellie died. Dean also argued that because the joint tenancy wasn't terminated, he had the right of survivorship, and Nellie's interest automatically transferred to him at the time of her death. Following discovery, both parties moved for summary judgment, and the court granted summary judgment for Dean. Mower filed a motion for reconsideration, which the court denied. Mower then appealed to the Utah Court of Appeals.